Welcome to Shenkman Education. My name is Marty Shenkman. Topic for this video clip is going beyond guardian appointments. Everybody knows, if you have a minor child, you need to name a guardian. You do that in a will. You appoint a guardian. You need to name successor guardians in case the person you first named can't serve. Don't name couples, because if you name a couple and they get divorced or one dies, what does that appointment mean? And is there going to be a legal battle over who's the guardian? But let's go beyond that, because that tends to be one of the only things talked about. So first of all, let's get a little deeper on guardianship. You can appoint a guardian for the child as a person, guardian of the person, maybe different language in different states, and a guardian for the property. What's the distinction? The guardian of the person is the one who makes decisions about a child going to school, private school, summer camp, health care, etc. Guardian of the property is the one that invests and manages the money. In almost all instances, it's done as the same person. It need not be, because you may have somebody that is like outstanding in terms of their relationship and compassion for your child, but somebody that may not be as astute as perhaps you need in terms of finances. You can name separate people. The more common way this is really dealt with is setting up a trust for the child and name a trustee to be in charge of the money and separately a guardian to be in charge of the person. Now, there's pros and cons to using the same person or different people. If you use the same person in both positions, there's not going to be any conflict and the guardian can get whatever money they need. On the flip side, that deletes, eliminates, prevents the kind of checks and balances you may want if you're not here to make sure your child's taken care of. So in other words, if you have separate people appointed as guardian of the person for the child and a separate trustee, you have two people that can kind of exert a check and balance on each other to make sure the child's properly taken care of. Let's change gears. Just dealing with guardianships and trusts for a child is not enough. Do you have life insurance in case you don't have enough assets to make sure the child can be cared for? Let's go into another direction that's really important and often overlooked: disability. At many ages, certainly in your 30s, 40s, maybe even beyond, the statistical likelihood of a long-term disability is probably much greater than death. What about planning for your minor children if you should become incapacitated? You should have a durable power of attorney where you name an agent to take care of financial matters, but you should also expressly address taking care of your child or children. Further, what happens if the child's over 18 and you want to provide for them financially? Most people do. Once a child is no longer a minor, can an agent automatically provide for them? And if not, what should you put in your durable power of attorney for financial matters to make sure the agent has authority to deal with them? Another matter, commonly used revocable trusts often only focus on avoiding probate on your death. It can be a powerful tool to manage assets, not only on your death for children or other heirs, whoever you wish to name, but also while you're disabled. If you have a successor trustee and you're incapacitated, that successor trustee can step in and take care of not only you, but your children. You need to expressly address that and make sure they have authority to distribute money to and for the benefit of a child, and even a child perhaps that's over the age of majority. If your child is 19 and still in college and you're covering all their financial expenses, you don't want that to stop because you're incapacitated and can't do it. That needs to be addressed. Planning for disability in the care of minor children is often overlooked. Another aspect in caring for children: if you have an adult special needs child, deal with the disability planning. Too often people only focus on, gee, do I have a special needs trust under a will or revocable trust in case I die? It's not enough. What if you're incapacitated? If you're the primary caregivers or a successor guardian appointed, maybe you want to have a court proceeding and name a successor guardian so you can choose who will take care of your child if you're incapacitated. Stuff happens. Life has no certainties. You want to make sure you deal with the what ifs that could really have a dramatic and negative impact on your child. Thank you for joining me. Keep in mind that all the information on this video is for informational purposes only. Don't take any professional action without seeking appropriate professional advice. And keep in mind, especially on some of these topics, the rules differ very much from state to state. And it's not only about legal documents, it's about finance, insurance, and everything else to make sure you've done a whole package to provide and protect for your children. For more information, see shenkmaneducation.com. Thank you.